Hello, everyone. I am happy to introduce you to Mr. Rajat Pradhan. So today we have a very interesting session on DPDP Act, the Digital Personal Data Protection Act. Rajat Pradhan is the associate partner of Solaris Legal, and he will be sharing gyan with us on DPDP Act. DPDP Act is quite useful act because it tells about our rights in terms of privacy. Privacy has become a very big thing in the age of digital dunya. Why? The reason is because anything we do online, our data is recorded. And what are our rights related to our data? Those are defined by this act. So over to Rajat. Rajat, can you introduce the DPDP Act a little bit and then we can go ahead and I will ask you specific questions.
Thanks, Saurabh, for the kind words. With the new age and the data becoming porous day by day, I think we are standing at a threshold where data privacy is not just as a means of compliance and what to do, but it is a way of doing business. So let me share a statistic with you that there was a survey conducted in October 23 by EY. Now, 76% of the respondents said that the way a company handles its data privacy and its commitment to data transparency, sort of shapes the data preference and how a person buys a product or not. So, as I said, it is just not a way of compliance, but how a way of doing business. And we are standing at a watershed movement where this law is about to be brought in force. The act is already in place. The rules were notified in January 25. The consultation by the ministry is over last month, and hopefully we should see the rules being notified closer to this end of this year.
So, Rajat, basically, when it comes to privacy, can you introduce this concept in a way that any common man can understand? Why is it important? Why is it becoming more important, like especially after the age of online apps and now AI is also coming? Why is it a very important thing? Like, leave aside DPDP Act. Why privacy, saving our privacy online is very important in this day and age?
So, I think privacy, just aside of the DPDP Act, it's a fundamental right guaranteed to you by the Constitution. When I say guaranteed fundamental right, it is a part of right to life and personal liberty. That's what the Supreme Court has said in 2017 by a nine-judge bench, that privacy is a guaranteed fundamental right. And everyone, in simply put, has the right to be let alone, so that your data, your essential characteristics and traits are personal to you. And with the age today that even for ordering groceries or just from booking your tickets or maybe just as simple to booking a cab, privacy is here because while you do all these functions, your data is being processed by someone. And if you do not have checks and balances, there's a lot of potential misuse. And with a lot of innovation going on with the scams, digital arrests, so it's important to sort of safeguard your data. And we have prepared a presentation, and sort of if I have your go ahead, then we'll get on to that.
Yes, so I'm very happy to listen to you. And I think your presentation will be showing us the way forward. Especially like myself, I am a startup founder. I think DPDP Act has a lot of ramifications for startup founders and even the common people because we will know about our rights. And Rajat, one thing I wanted to ask that I've heard that DPDP Act has been notified, but the rules have not been notified. So what is the timeline according to you of notifying the rules?
So, as I said, sort of the consultation and the government had invited a lot of comments on the rules because the act is in one place, but the rules will sort of operationalize the act. The public consultation on the rules was over in March 25, and the government is now mulling over these considerations and the comments that have been received. And once that is in place, I believe the rules should be notified later this year, but with the caveat that the rules itself, the draft itself, which was released by the government, says that the implementation will be in a phase-wise manner. When I say phase-wise manner, only certain provisions of the rules will be brought in force. So there is a body called Data Protection Board, which will be overseeing, the aspect of data breaches and passing directions. The government will first have those rules in place, but the remainder rules, which is actually the compliance bit and the obligation bit, will not be brought into force immediately. And that will be a subsequent development after the Data Protection Board is operationalized. And if I understand correctly, it's not that from day one the compliances will be expected to be in place, but I think a runway period maybe of 1 year or 2 year will be given. But I mean, I sincerely, as a practitioner, believe that this is the time to prepare for what is coming, because data privacy will impact right from smaller to bigger businesses as soon as it is operationalized.
So I'm seeing that the government is very serious relating to DPDP Act. In fact, there was a consultation program recently in Indian Habitat Center where the minister concerned, Mr. Ashwini Vaishnav, he was sitting and there were all these bureaucrats sitting, and I think there were more than 400-500 people who asked questions, shared their opinion about the DPDP Act. So it's a good thing that government is making things very democratic. People are allowed to directly represent in front of ministers and bureaucrats, and the government is taking that feedback and drafting rules accordingly. And like Rajat is saying, like it will be in a phased manner, which is very similar to how startups do. So you have a minimum viable product and you do things in phased manner. So with that, over to Rajat. So Rajat, please present your presentation. I feel people will get a lot of gyan from it, and it will be very useful for people.
Thanks, sir. May I request the presentation to be shared on the screen? So the first bit is the evolution, how data privacy as a right comes into being. As I said, it is a fundamental right guaranteed under the Constitution, which has been recognized by the Supreme Court and Justice K.S. Puttaswamy. Now, it's not like that there is no existing legal mechanism to govern data privacy. We have the Information Technology Act. We have something called the SPDI rules, which have been in place since 2011. But the focus of that existing legal regime is sort of, on information security rather than how the data is being processed. So we have the DPDP Act in place. The rules will operationalize the act, which are expected later this year. And then the act will actually be, in a sense, be into play. Next slide, please. Now, before we actually jump into the law part, there are certain basic concepts that are the cornerstone of this act or this legislation. One is the digital personal data. So this law only governs digital personal data, which is that any individual should be identifiable with that digital personal data. So this is the ambit of the act. The second is data principle, which is you, me, I, everyone else, the common man, for whose benefit this law has been brought into force. So that is, and any individual is called data principal whose personal data is identifiable. Now, in the context of children below 18, since they're not majors, it will be the lawful guardian or the parent in that case, and so as the case for a disabled person. Now, the data fiduciary bit, because a lot of obligations are coming. So when I say data fiduciary, in simple words, it means data controller. That any person who determines what is the purpose and means of processing personal data will be a data fiduciary under this law. Now, the government has the right to notify certain data fiduciaries as significant data fiduciary, which will happen after assessment of a lot of factors like the volume and the sensitivity of data, the risk to the rights of data principal, and impact on the nation's security, public order. So that entity will be called a significant data fiduciary. I mean, what I anticipate that large social media intermediaries who process large chunks of data may be brought into this ambit. While this may be, prediction, but we are yet to see how the central government approaches on the notification bit. Next slide, please. As far as processing goes, so any data which is being handled in simple terms has been defined as processing. Processing can include as recording, organizing, structure, storing data. So anything to do with processing is within the ambit of this act. Now comes the concept of data processor under this law. So data processor and data fiduciary work hand in hand. So suppose the data fiduciary outsources a particular purpose to a data processor, it will be handling or processing personal data on behalf of the fiduciary. But the only distinction is that the data processor will never determine the purpose of what to do with the data. That alone lies, that control lies with the data fiduciary. An example would be like a payment gateway, which is being hired by e-commerce companies to process the payment, or maybe a third-party administrator. Suppose if you go to a hospital, you submit your documents, you're actually insured by a different company, but the claim is being processed by a TPA. So TPA in this example would be a data processor. Now, the Data Protection Board, as I mentioned earlier, is a body which will be established by the government to pass directions on complaints of breaches and observance of fiduciary's obligations. Now, it will be a body which will have wide-reaching powers under the Data Protection Board. It will be housed by a chairman and members. And interestingly, the government proposes to have this office as a digital office alone, as far as practicable. They will have wide powers to impose penalties in cases of data breaches, and the penalties somehow, which are mentioned in the act, go up to in the region of 250 crore. But that is not to say that in all instances that penalty can be triggered. It is, I think, some sense of rationality and proportionality will guide that imposition of penalty by the board. Next slide, please. Now, the applicability of this law. When I say applicability, it means that it will apply to all data processing within India, outside India. Now, when I say outside India, so suppose if you order a product from a foreign company or maybe a foreign quick commerce company, because the foreign company is processing your data in this case to deliver the product in India, even that foreign company will be required to follow the obligations of the DPDP Act. Now, there is one aspect that this act does not apply if you have yourself put your data in the public domain, because consent is the main factor of this law. You can allow, you can give your consent and then alone your data can be processed. But for instance, if one person has put its personal data on a, say, Facebook or on a Twitter, then it cannot be said that the obligations under this act will be triggered. Next slide, please. Now, when or what are the grounds for processing personal data? As I said, consent is the cornerstone of this law. Your data can only be processed if you are consenting to it. The common man is at liberty to withdraw its consent. So as soon as the consent is withdrawn, the data processing cannot be done. And when I say consent, the consent has to be specified and informed. You would have seen that we use a lot of apps on a day-to-day basis, and then a pop-up comes that, do you agree to this? There are instances we have to say yes, and then only we can proceed to the next page on an application. But once this law comes into force, I believe that will change significantly, because your consent has to be in a very specific and an informed manner. And there are certain conditions when your data can be processed without your consent, which the law provides. That is when the state is giving you some benefits or subsidies under the law, when any court order has to be complied, or someone has to respond to a medical emergency. These are the critical carve-outs where consent is not required for processing personal data. One important aspect is that if even for employment purposes, consent is not required, but we have to see how this plays out, because the law has broadly said that for employment purposes, data processing can be done, but it has sort of carved out that only in instances where the employer sort of foresees that it might be undergoing a loss, or its data might be compromised by the employee. There might be instances of data leaks. Then the employer doesn't need to take the consent of the employer for processing the data. Next slide, please. Now, coming to the obligations or the compliance bit for the data fiduciaries or the entities which will be handling data. The cornerstone is that a notice has to be given every time a data processing is done. That notice either has to be given before or at the time of obtaining consent. So, for instance, if you go to a bank to open a bank account and you have consented to undergo the KYC process through a Zoom call or a video call, the bank, being the person that will be handling your data, is under an obligation to give you a notice either before it does your KYC or at the time of doing KYC, that why all your taking consent is necessary. So this notice will have to give you. Now, one challenge as we see as practitioners is that this provision will apply prospectively, that is from the future. But what happens to the data that is already in the domain or data which is already with applications and quick commerce companies? So there is little guidance that, till what period, while the law says that, a notice has to given even for historical data, but it doesn't so for how long back, 10 years, 15 years, 20 years, because data has been being processed, unimaginable that from times to come. But it doesn't say that, till what period before the act came into force, this notice requirement will be there. Now, the notice that will be given to you before data has to be processed is required to be in a very clear manner. It required to be in a very simple language. And an option is to be given to you in probably not just in English, but other languages recognized by the Constitution, so that it is easily comprehensible. And it is required to be given independently. When the law says independently, it means that your consent cannot be, you would have seen when you access a lot of websites, a pop-up comes that please agree to our privacy policy. When we click yes, it's implicitly you are giving consent to that application. But after this law comes into force, that will change, because a consent will be required to be taken independently of any other aspect. Next slide. Now,
A small question, Rajat, at this stage. So, say for example, if I'm using some website like YouTube or Facebook, so for every post they will be taking a consent, or is it just once when I will log in they will take, or is it just once when I create the account they will take? Like at what time they will take the consent?
so I think once you are opening an account, your consent will be taken but that consent is for a specific purpose for opening your account. So suppose YouTube needs to process your information for any other purpose which is apart from opening an account. I believe again YouTube will have to take your consent for any other purpose apart from that.
Okay, and this consent, like I think you will be covering that later on. Like what happens in case of kids? So, for example, if my daughter who is in school, see these days kids go and they open their own accounts, and especially in games they do. So, does this act cover that also, or is the act silent on that?
And thank you for the question, Saurabh. This is a very pertinent topic in today's age when our children are operating gadgets and they're opening accounts on social websites. So what the act says that in case a minor which is below 18 years is opening account, consent will have to be taken from the parent. One gray area is that this consent from the parent only comes into play when the child actually discloses that he or she is a child. So
Hmm.
the act assumes there would be no potential misuse, and the children will be forthcoming while using any application. And the children's consent, parents' consent will be mandatory before a child's data can be processed. So but the way of obtaining consent, as I'll be discussing later, is slightly tricky. But of course, the government has done its best, I believe, in the draft rules.
And is that similar to COPA? Like COPA is in America, or is it something a little different from
So
that?
I think it's slightly different, Saurabh, because in COPA, what I understand, COPA itself says that how to obtain verifiable consent from a parent. But Indian law is somewhat silent on this. It does not specify, I mean, in a country of 140 billion where technology is not so being rampantly used and has not spread to every nook and corner, the way a consent will be obtained has not been specified very clearly, as it has been done in COPA, like sending an email or the parent interacting over a video call and giving consent. But that is not at least seen in the regime which is in place right now.
And my last question before you continue is that is the consultation process still going on, or is it over now?
So the consultation sort of is over. The government is mulling over the written representations that has been taken. And interestingly, the government extended the deadline for to maximize the participation of players and from different industries, and hopefully that will be reflected in the rules once they are notified.
Okay, okay. Rajat, you can go on.
So coming to the contents of this notice, the notice will have to tell you as an individual that why your data is being processed. That is the specific purpose. The notice will be setting out an itemized description that what all data is being processed. The notice will say the goods and services that will be given to you through the processing of the data. Now, these are the mandatory contents of the notice that are supposed to be given. Now, there are a couple of additional requirements of the notice, which is a link has to given to you so that if you want to withdraw your consent, you can easily withdraw in a manner with the equal ease with which you had given your consent. Second, the description of information, how you may exercise your rights. It will basically set out what all you can do with your consent. And of course, how you can make a complaint to the data protection board in case you have any grievances. The next concept where consent is important is that of consent manager. Now, this is somewhat a departure from the international regime that Indian law has recognized or introduced the concept of consent manager. The consent manager, in simple words, is just a platform where you as an individual can go and give your manager consent. And on that platform, the law presupposes that the data fiduciary will already be onboarded so that your discussion or your consent can be processed. But the consent manager is supposed to be your representative, that is your individual's representative rather than the person who's processing data. So the law says that he will be acting in your fiduciary capacity, and the consent manager will be required to have a separate platform. Next slide, please. Now, this is the second key compliance obligation, which is reasonable security safeguards. If an entity is processing data, it is required to have security safeguards for safeguarding data breaches. Now, while the law says reasonable security safeguards, we are seeing in the act that minimum thresholds have been prescribed. I mean, it doesn't say what maximum, what is the best practice, but it says that to safeguard your data, the data fiduciary can employ means such as encryption, masking, obfuscation of data, strict access controls to computer resources, which means even in an organization, businesses will have to be tactful in limiting the data access to individuals who are actually handling a specific purpose for that data. The third condition is that organizations might be required to maintain logs, who's accessing data, so that tomorrow if there is a question that how this data was processed, there is a visibility as to how data was processed in terms of the logs. And in case any data is compromised, the law says you have to maintain those logs for at least 1 year and the data in question which was compromised, so that if there is any investigation by the authorities, the data can be easily be accessed. Now, one of the security safeguards is also, as I mentioned, that if data processor is processing the data on behalf of data fiduciary, the way data fiduciary will engage the data processor is to enter into a contract. Now that contract, while what all is to be mentioned in the contract is not there, but whatever data fiduciary is taking best measures, Even data processors, we believe, will be required to be taken, but ultimately they will be handling your data. Now, there is one challenge. What we see is that while the law is not saying what is the minimum or the maximum security safeguards, at the same time, while it will give flexibility to businesses, it is somewhat ambiguous also, because the existing regime, which we indicated in the beginning, which is the IT Act and the SPDI rules, they prescribe certain global standards, that is ISO, IEC 27001, which have certain yardsticks of measuring that what all safeguards are to be there. While I see that this is a flexible approach, uh, it also means that different businesses will read this requirement differently. So there is, I think, some scope for clarity on this aspect. Next slide.
So, Rajat, is there any like criteria like beyond which this will apply, or it will apply to any startup, say some website, just a small website? Will it apply to that also, or will it apply beyond a certain threshold?
Sort of, it only says it applies to data fiduciary. So even if you are a small business, even if you are just a data, you are processing data for any commercial, non-commercial purposes, that's the strict reading of law, that you will be required to have these safety secure guards in place. I mean, while international standards are there, so I mean, that's where I think the law comes to the rescue of smaller businesses, that while it is flexible, but the law prescribes minimum security standards, which are on the screen, that encryption, obfuscation. And I might say that these are best practices that a business can opt, rather than engaging or spending, allocating a specific budget to this. But we'll have time will tell that how will this be implemented, in a sense, how the government is going to take this in perspective.
Okay. And will you be sharing some of the penalties or some of the things which government will do, especially in context of SME businesses? Because I think compliance will be a burden for them initially.
Absolutely, so I think there is a growing concern that how MSMEs, smaller players, will comply with these obligations. And what I believe, that adequate representation have been made by industry bodies on behalf of these organizations, sort of to take care of their interest. While saying that, there is a provision under the law that the government can exempt certain startups or certain bodies after seeing the nature of their data processing. So if these small players are to be safeguarded and these thresholds are to be lowered for them, the government equally has the power to sort of segue in a place where these MSMEs, as you are mentioning, or the SMEs are, or the rigor of the law is relaxed for them.
Okay, so maybe in rules, government will take suggestions and based on that create thresholds for easier compliance for smaller organizations.
It's possible. The government has the power to issue directions also from time to time. So maybe it will invoke that power to sort of seeing the nature of a body and then exempt it from complying with certain
Okay.
obligations.
And this act comes under MIT, na?
That's
Ministry
correct.
of Information Technology.
That's correct.
Okay.
Now comes the aspect of data retention and data deletion. Uh, Interestingly, the law says once the purpose for which the data is being processed is over, when the data fiduciary thinks that or it can reasonably assume that the purpose is over, it will have to delete your data. So suppose if you go to a car company to buy a car and you purchase the car, or if you log on to a quick commerce company and that I want to rent an accommodation, once that purpose is over, the reading is that your data should be deleted because the purpose has been over, which I anticipate might be a bit of challenge. But at the same time, the aspect or the larger objective is that the data should be processed for a specific purpose only. And once the purpose is over, it should be deleted. And of course, the data has to be deleted when you withdraw your consent. So you as an individual can send an email or access the app to say that I am withdrawing my consent. Please delete all my data, and the data fiduciary will be under an obligation to delete the data. But the law also says there are different regimes which say that the data has to be preserved for a longer period. So, for instance, banks are required to maintain the data for 10 years since an account is closed. I believe under the Income Tax Act, also the data is required to be retained for the revenue purposes for a longer periods. So, as far as these objectives are concerned, these threshold of deletion of data after the purpose is over will not apply to them. Now, the law also recognizes three types of data fiduciaries who can retain their data for 3 years. The first is an e-commerce entity having not less than 2 crore registered users in India. The second is social media intermediaries having not less than 2 crore users in India. The third is online gaming companies having not less than 50 lakh registered users in India. Now, if your business is falling into this criteria, you can safely retain data for 3 years and you need not delete the data once the specific purpose is over. And if you are falling into one of these buckets, that is, these three entities, even before deleting the data, the law says you need to give a 48 hours prior notice to the data principal, notifying that we are going to delete your data unless you log on to our app or you log on to a system so that we'll get a signal not to delete your data. Next slide, please. Now, a very critical aspect of this law is to prevent data breaches and how to take measures once a data breach is happening. Now, if a data is compromised, if a data breach happens in an organization, or if a data fiduciary thinks that the data is leaked, it is required to give without delay about a notice of this breach in a concise, clear, and a plain manner to the data principal. It is required to intimate. The intimation can be either through a registered communication, it might be an email, or it might be an app notification, or any other mode through which it can be reached to the data principal. Now, the details are to be provided, says that about the breach, potential consequences, mitigation measures, and contact details of the data fiduciary representative. So, businesses need to find someone in the organization who can handle queries regarding the data breach so that the data principal know what the business is doing about data breaches. There is a second requirement that the data breaches are to be notified even to the data protection board. Now, this is a two-step reporting. The first report is on a without delay basis. I mean, as soon as the breach occurs, you need to tell the DPB that what is the extent, time, and location of the breach. Within 72 hours, the organization is required to conduct a detailed inquiry and then report back again to the protection board about the description of the breach, the events and causes of the breach, the mitigation and the remedial measures, findings on individual responsible for the breach, steps to be taken to prevent reoccurrence, and report on notification made to effective data principal. Now, there are certain challenges. What we perceive while we read the law is the law does not say that what is the threshold of notifying a breach. I mean, a breach can be a small breach as someone taking your data in a pen drive and walking out of your organization. The breach can be a ransomware attack or paralyzing your systems, and that is also a data breach. So I think what we see, maybe a risk-based approach might be better, because suppose if the breach is being notified, even the smaller breaches are being notified. I'm not sure to what extent they can be looked into by the DPB, and it might be a fatigue for the organizations and even for the DPB to handle such breaches. There is a parallel reporting requirement. There is already a body called CERTIN, Computer Emergency Response Team, to which data breaches are required to be notified within 6 hours. So, in a sense, it's a parallel reporting requirement. I mean, time will tell if this reporting requirement to CERTIN will be done away for data breaches. There is also parallel reporting in terms of, so suppose if you are a listed company, you are required to intimate the stock exchanges about the cybersecurity incidents or data breaches. So there is somewhat a parallel reporting requirement coming out after this law comes into force. The timelines, of course, some bodies have reported that these timelines are very short, within 72 hours. It may not be in a position to conduct a detailed inquiry and then get back to the DPP. And then, as Saurabh was saying, it might be slightly burdensome for smaller players like SMEs, MSMEs to comply with these obligations of intimation of data breaches. Next slide. Now, Saurabh, coming back on the impact of startups. Now, this data protection law, the central government has the power to exempt startups from complying with the following requirements of DPDP. Now, once this is there, it's not as if all startups can be exempted. The law says, given the nature of data that is being processed, or the volume of data, or a particular data, then the government can sort of exempt you from complying with the obligations. Now, and it's not like all obligations will be exempt. The law says that the requirement to give notice for obtaining consent can be relaxed. The requirement to ensure completeness and accuracy of personal data when it is being used to impact the decision of data principle can be relaxed. The data retention and erasure requirements, what we just discussed some time back, can also be relaxed. So, I mean, a messaging to all businesses who are running startups that it's not that these compliance obligations will be impacting all across the board startups. The government has the power to exempt certain startups. But in terms of startups, the key compliances, what we feel are required to be done is that as I said, the cornerstone of this law is that only specific and minimum data should be collected. So if the specified purpose is known to the startup, it should only collect data for that particular purpose and nothing more. And second, because we discussed that once the purpose is over, the data is required to be deleted, that aspect needs to be kept in mind to startups. And they also need to establish internal processes, maybe identify individuals who are key to the handling of data, and a robust security measure to prevent breaches. Data transfers outside India, I believe, will be a certain impact to startups considering a robust IT system that we have in India. Now, what the intent of the law is, it is sort of targeting a data localization, which means the government is pushing it, please keep the data within India. But it's not as if the government is prohibiting data being sent outside, but it is saying that we can, as the government, certify or come out with a list of countries to which data cannot be sent. There is a somewhat, I would say, variance between the Act and the rules. While the Act mentioned that the government can restrict the nations and stopped at it, now the rules are saying that the government can notify requirements while you are transferring data to certain nations, which means that even if you are permitted to transfer data to a particular nation, the government can put certain contingencies, requirements that you have to comply before you send data to that particular nation. Next slide. Now, again, coming back sort of to verifiable consent and impact on edtech companies. So as to say, because children are vulnerable in this today's age to cyberbullying, to a lot of cyber malpractices to which they can be exposed, law says that verifiable consent has to be taken. Now, verifiable consent is that of the parent. So, as a business, if you're processing data which involves any product related to children, as a business, you need to ensure that before you process the data of a child, you need to take the parent's consent. Not just the parent, as a business, you will be required to ensure that the person who's actually giving the consent on behalf of the child is actually himself or herself an adult. Now, the identity of that parent can either be obtained if that parent is supposed registered on your portal or a business, you can identify that person as, yes, I rely on this data. Second is maybe these details can be taken from DigiLocker or from any agency which is authorized by the government who is a repository of that data. And of course, the third is if the parent voluntarily provides the data to the business that this data is being given by me so that you can process it too. offer any good or service to my child, then of course you can obtain verifiable consent. Now, there is a prohibition under the law that businesses cannot do a behavioral monitoring or do tracking of children. I'm sure there might be instances you all would have come across that you are talking about a certain product and you scroll down through Facebook, suddenly you see a pop-up of that particular product advertisement coming. So there is a tendency of certain apps to to monitor your behavior or to do targeted advertising. The law is prohibiting this when it comes to children. Having said
Well,
that,
just to get an idea, Rajat, I have a question because I run a startup called Fun to Do Labs, which is into edtech, and it directly concerns me. So, say we are creating an app for teaching math. That app says downloaded by most probably parent, but even kids can download it. So at that time, like how will I check? Like in Copa, the threshold is quite low. So they just need like they ask like what is your date of birth, or they ask just what is your year of birth, something like that. And if say I write my year of birth is 1975, then it will say that, like this is okay, and it is a adult giving permission, and it allows. Copa is quite lenient there.
correct,
The way Apple and Google check on app stores, generally they check only that kind of thing. It is called parental gateway. So
correct.
so same thing is here, or like I would have to go and as a parent put my Aadhaar number, and through that something like that. Like is it clear, or will it be clear once rules come?
I think sort of, as I said, there is a big loophole right now that the child has to first inform that it is a child, or he or she is a child. So your obligation only comes into play when the child is disclosing. If the child is downloading your app, you are under an obligation to take the parent's consent before you go ahead with the providing services. But if the app is being downloaded by a major, maybe what I understand, maybe a parent downloading the app on behalf of the child, I believe then the requirement is not there. But I mean, in today's age, what we are seeing, children are becoming way more tech savvy than we are. They're accessing gadgets, but if they disclose that they're a child, I believe the obligations will have to be complied
So
by them.
it will be like as a lawyer, like can you guys? So basically, it will be like when you download, there will be a screen. Are you a child? Are you an adult? I understand most kids will choose adult only, but like as a app developer, we have to give that kind of a screen. And if it is a child, then the whole process under DPDP will apply, and if it is adult, then nothing will apply. Something sort of that will have to.
Absolutely, Saurabh. Absolutely.
Okay.
That's how it
And
should.
what are the penalties for such companies? See, like for example, we are a genuine edtech company. We don't require too much data, but obviously there are genuine issues. Like for example, if I am giving some game or some questions, I need like how many kids answered as a, like not specific kid, but at least I need as a group how many kids are answering or not answering specific things. So is a, like if you collect anonymous data in a group format, is it different from if you collect it specifically identified to an individual, or like the law is silent to that?
So I would say as long as you can identify a data to a particular child, then these obligations will kick in. But if it's a data which is in a masked form, which it just says that there are 40 respondents, then perhaps there is a gray area. But I mean, as a practitioner, I would say that it's better to tread on the side of caution and read the intent of the law, which is to prevent I mean, children from being exposed to certain data processing, which is detrimental to their condition. So anything which even remotely can suggest that a child has to do with something to with their data, I believe and I understand that these obligations will come into play. But if it's an anonymous data, maybe like a genuine survey, uh, probably that won't be triggered because you're not processing the data for offering certain services.
And once the parent gives consent, then it's normal. Like for example, in COPA, there are restrictions on like you cannot open microphone or video, or things. But here you can open microphone or video once the parent gives consent, as far as I understood things.
That's correct. So once the parent has given the consent to that specific platform,
Okay.
that this data can be processed of my child for this particular purpose, then you can go ahead with that. But if you are changing the nature of the service or maybe a new product is being offered, perhaps it might be a cautious tack to take the consent once again.
And like a interesting question I have, like, say for example, you have apps these days like YouTube and Facebook, everything is available on mobile as well as web. So for example, if somebody opens a account on mobile and can consent be taken on web, or they open on web and consent be taken on mobile, or does the act or rule say something about that, or like that is the act is silent about that?
I think, Saurabh, if my memory serves me correctly, that way the law has given you, I mean, I think it defines platform. That platform can either be a web-based platform or maybe an in-app notification. To that extent, there is some flexibility how the consent is being obtained as long as the contents of the notice requirements are being fulfilled. It can be a app, it can be a mobile.
So if I take consent on web, my mobile app will also be automatically deemed to have taken consent now.
Absolutely.
Okay.
The idea is also to prevent consent fatigue, that it shouldn't be
Yes.
becoming difficult for the consumer that he or she needs to, give consent for every. I mean, that's a practical way of,
Yes.
I would think that would be going ahead.
Then people stop reading and they just like in what these Europeans have done. We do, we go to the website, we say accept all. We don't read all the things.
Absolutely.
Okay.
So the next is data processing of employees. I believe this is something that will be relevant across the board, irrespective of the sectors. Now, an employer, an individual will be, of course, a data principal. The employer will be the data fiduciary. In any third party processing, like a payroll, because a lot of MNCs or companies outsource their payment functions, they will become the data processor in this scenario. The law says the employer can process the employee's data in certain situations, which are like for safeguarding it from loss or liability, for maintaining confidentiality and trade secrets, for prevention of corporate espionage, for providing any benefit or services sought by the employee. So we are facing instances where there is a lot of data misappropriation or mishandling of data, maybe intentional, non-intentional, by individuals in an organization to safeguard that interest. The law says you can process an employee's data, and for which a direct consent may not be needed. Now, a lot of questions we receive is that suppose an employee leaves the organization, is the employer required to delete its data? While the Act is not giving a straightforward answer to this, it is saying that employer must delete employees' personal data once it is reasonable to conclude that the specified purpose has been achieved, unless retention is required. So if there is any specific purpose you believe there is an ongoing inquiry or investigation going against an employee, you can retain the data. But if an employee is exited, there is no specific purpose, who are that employee, then probably the requirement can be read or may be read to mean that that organization may be better placed if the data is deleted, but we are yet to see a clear cut answer in terms of that. Next slide, please. Now, one of the aspects of the topic is the opportunity of the DPDP. I know for the past 10 slides, I'm talking about compliance as an obligation, but there is a positive or a uptick of opportunities which are coming across once this law is there. One is enhanced trust from customers and investors. The second is competitive advantage. Of course, the perception of an organization which is a compliant is going to be, a lot better than an organization that is not compliant. And I believe even for startups, their valuation will go up if they have a higher threshold of data privacy practices in place. And of course, it will be aligning with global standards. Data within the organization will be streamlined, and enhanced data security measures will be in place as in terms of an opportunity, what we see after this act comes into force. Next slide, please. Now, very briefly, the steps that can be taken by businesses, and I would say this is a preparatory phase once the rules get notified, is A, first of all, identify the data within your organization. There might be certain sources of data in the organization, even if it's a mid size or a large size, there might be various sources of data. So first, sit down maybe with your team and identify the sources of data. Be in readiness and prepare the data notice which is to be given to your consumers or customers. Identify data processors because they are going to be playing a very critical role in the data privacy journey because they are processing data on your behalf. Align your data privacy policies in accordance with DPDPA, which include identify why you are processing data in the first place. You should retain and deletion timeline should be carved out and sort of fleshed out so the organization, everyone is aware. Set in place a grievance redressal mechanism, maybe have someone in place who has knowledge of data privacy and how data is administered. So that person can respond to queries if there is any aspect of data privacy. And then implement reasonable security standards, which is an obligation under the Act. And then, of course, have a sit down probably with all of your employees and make them aware of how data is to be handled and the obligations under the DPDPA. So I think that's it from me. If I
Okay, so we have very little time left. An interesting question Mr. Kulkarni asked is how AI is seen in DPDP. So, does the act talk about AI, or I feel that, as per my personal knowledge, like AI came just in last 1 or 2 years, and DPDP has been a going thing for last 2 3 years. So maybe the act is silent on AI. What do you say, Rajat?
I think it is silent, sir, but we are seeing AI. I mean, is being used very widely, efficiently. Of course, the AI system becomes, or it has a tendency to tutor itself by the data that we feed. So suppose if you want a draft to come out of AI based, you will feed in certain data into that. The AI will teach itself. So there may be implications on AI also to what extent it can process and learn from that data, which I think the legislature will have to sort of tackle. I mean, in the existing set of rules and the legal regime, there's not much guidance, but I believe there will be some guidance in the future once the rules are in place and the government will be mulling over it.
Okay. So, a question which Mr. Amit Taneja is asking is that for companies who have already ISO 27001 certification, how future ready they are with basics of this act. So do you have any idea about ISO certification and its ramifications on the compliances?
So I understand sort of the regime which is right now in place, the SPDI rules, they are prescribing that ISO certification requirement. While I mean, I I'm not sure of the exact particulars of that ISO certification, but I would tend to believe that if that certification is in place, you will be already in compliant with a lot of obligations. But since these certification itself are pre-dating the DPDP Act, you need to be sensitized of the requirements under the Act so that you can comply with the minimum safety security standards and see how they sit well with the ISO standards that your organization might already have.
Another question, Rajat, I have this question, like, does this act only apply towards private organizations, or does it apply to government's own departments also?
I think that's the beauty of the Act, sort of, it applies to the government as well. And I think it's a master stroke. There is a specific schedule under the rules which says that what is the data processing. I won't say it's very exhaustive, but there are certain standards prescribed for the government while it is processing the data of the common man. So it applies across the board. But of course, there are certain exemptions that if the data is to be processed by the government for security reasons, or maybe for certain specific reasons of giving you benefit, then the government is exempted from a lot of obligations.
Okay, my last question, because we are having lack of time. So one question by Professor Ajit Moria is that working on data breaches, how and by when one can say that such risk is fully under control, and what happens, like Dr. Umesh Devagna has this question. Is secrecy maintained by the private organization? So I'm not very clear about the question, but like going by some questions which I'm reading, what happens if the data breach actually happens? What happens then? Especially what action will government take at that time?
So it's a two-step sort of what I see. Once the data breach happens, you have to notify the data principals or the individuals whose data has been leaked with details. The second is you need to notify the data protection board, and then you need to sit down and identify the particulars of the breach, which is mandatorily required to be notified to the data protection board. But once the breach happens, probably as an organization, you should have measures in place so that the data breach can be identified, and maybe there's a lot of safeguarding in terms of cyber risk insurance which companies take to ring fence themselves. But as far as individuals are concerned, there is an obligation of notifying to them as well as the data protection board in case of.
Are there any monetary penalties also?
They are huge, so to be frank. But of course, it's not to say that these penalties will be applied across the board. There are penalties if you are not having safety security standards like in place. There are penalties if you do not notify data breaches to individuals or data protection board. Uh, there are penalties even for data principals like individuals, that if they impersonate their identity, and they can be penalized. But after a detailed inquiry is conducted and opportunity is given to the organization, then only these penalties can be levied by the protection board. And there
Are there any criminal penalties also, like jails or something related to that?
not what I see sort of in terms of the DPDP Act per se, but what as a practitioner I can say it will trigger certain offenses if the data breach is extensive in nature, or if there is a suspicion that data has been sold, and if there is any involvement of theft or cheating, then yes, it may involve a.
So all the other provisions of Bharatiya Nyaya Sanhita, and like I'm not a lawyer, but most of the things which are there in CRPC and Indian Penal Code, they will still apply.
Absolutely, absolutely.
Okay. So we are reaching to the fag end of the session today. So thanks, Rajat. It was a very useful session for startup founders and for individuals using internet. And I think most of us are using technology these days. So DPDP will apply to us. So a very informative session. I have seen a lot of comments. At least 8 to 10 people have commented that it's a very useful session, and they have personally thanked you.
Well, thank you, Saurabh. Thank you for the great opportunity to AIMA and everyone for joining.
Okay, so okay, bye.
Thank you.
Thank you everyone for joining.